On a frigid January night in 2022, Boston police officer John O'Keefe was found lifeless in the snow outside 34 Fairview Road in Canton, Massachusetts. His body was battered, bloodied, and exposed to a brutal nor'eastern storm. What began as a tragic loss of a decorated officer quickly spiraled into one of the most controversial and emotionally charged trials in recent memory. His girlfriend, Karen Reed, once a finance professor, now stands accused of second-degree murder. Prosecutors say she struck John O'Keefe with her SUV after a night of drinking and then left him to die. But Karen Reed's defense paints a darker tale, a conspiracy, a cover-up, a house full of secrets where fellow officers allegedly knew more than they let on. The first jury could not reach a unanimous verdict in 2024, and now the stakes are even higher in the retrial. Today, one of the most important witnesses for the prosecution continued his testimony, an accident reconstructionist who was not part of the first trial. Will his testimony make the difference for prosecutors second time around? Tonight, we are live from the courthouse with all the big moments as the retrial of the century continues. I'm Vinnie Politan. Thank you so much for joining us tonight here on Closing Arguments, and we are in the stretch. We are in the stretch of the prosecution case in the murder trial of Karen Reed. Things are starting to wind down. And a lot of questions may still be in the air or may not still be in the air for this jury as they listen to the testimony. I want to go back to the first trial, though. And when I had an opportunity to speak to one of the jurors, Ronnie, from that first trial, and I asked him an important question. What do you think happened? How did John O'Keefe die? And he couldn't say how John died. He couldn't say. And that's why he voted not guilty, part of that hung first jury. But that's an important question that needs to be answered in this trial, especially for the Commonwealth, for the prosecution, for the government. If they want to convict Karen Reed, they've got to prove that and prove it beyond any and all reasonable doubt. So why is it in the first trial that after listening to all that testimony over all those days, weeks, and months, that a juror came out and said, I couldn't tell you how John died? Well, it's because the testimony of the only real experts from the first trial who testified about what happened, their testimony was ignored. I'm talking about the ARCA experts. The juror told me that they discounted that testimony from those qualified experts because they didn't know where they came from and why they were part of the case. Because they weren't hired by the defense, but they were called by the defense. But the defense and the witnesses weren't allowed to tell the jury the truth about why they got involved. They were hired by the feds, by the FBI, to take a look at what happened. But the jury wasn't permitted to know that. And as a result of not knowing the source or the reason why these highly qualified experts provided their opinions and testimony in Karen Reed's trial, their testimony was ignored. And like I said, they were really the only qualified experts. And when I say qualified experts, I mean people who do this for a living. Accident reconstruction, biomechanics, all that sort of stuff. That's what these experts were qualified to do. Now, on the other side, the Commonwealth did call a witness, but it was an unqualified expert, Trooper Joe Paul. And I'm sure a great guy. I'm sure he is an honorable member of the state police and does his job very well. But he was put in a position by prosecutors in that case to do something that he was not qualified to do, which was accident reconstruction at a different level. Like, this is a murder trial. This was a complicated scene, a complicated theory that involves engineering and biomechanics and a true understanding for this stuff. And yes, he's a trooper and he took some classes, but we're talking about next level stuff here, is what was really necessary for this jury, because his testimony did not convince the jury, and it probably shouldn't have, because of his background and experience in this very specific area. And there are a lot of experts around the country who do this for a living. And it's usually in the civil context of car accidents and things that happen where people are suing each other. Very common in there. And then once in a while, it migrates over to the world of criminal law. And that's what happened here. So in this retrial now, prosecutors went out and got a qualified expert, Judson Welcher. And the question tonight really is this the most important witness for the prosecution? Is this the witness that can put them over the top and help convince this jury beyond any and all reasonable doubt that Karen Reed's SUV struck John O'Keefe and then knocked him to the ground, causing his death? That's what they need. Is this the guy who did it? Well, let's take a look at his testimony, because it's worth taking a look at, because not just talking about what he believes is his opinion, but going out and doing some demonstrations and experiments and putting together a lot of evidence for this jury to consider. Take a look.
I did this at very low speeds, and you'll see, and we'll throw this from two different angles. That's me showing I'm doing test 2. This is from a camera that we have pointing down at it. This is the speed. You'll see it's only about a 2-mile-an-hour impact. But even a 2-mile-an-hour impact redirects me back and causes me to rotate and take a step.
Yes.
This is the post-contact image of the transfers onto my arm. Actually, the yellow paint you can see from my hand is here. This is from the arm and forearm. Here's the paint transfer pattern. What I've done is I've taken these yellow lines to show the extension of the components on the rear of the exemplar Lexus. Then I've done this extension of those same components on the rear of Miss Reed's Lexus, and shown how the approximate location of the fractures in the taillight match up with the approximate location of the contact of the arm onto the taillight. We've now overlaid the Lexus laser scans on top of the image of the Lexus. So there's the video image, a still image that we took from the video, and here's where we overlay the laser scan of the Lexus. So we've overlaid the laser scan of the Lexus onto the Lexus. We've overlaid the laser scan of the Chevrolet onto the Chevrolet, and we've overlaid the laser scan of the scene onto the scene. So now what that allows us to do, we now know the position of everything in there. And we've also tracked the position of the tire tracks. We lined it up in the video, we lined it up in the scene, we have the two vehicles. We can get the exact position of the vehicles when that Lexus stopped. So when that Lexus stopped, that's going to be the maximum engagement. So from that information, we can get the angle of the vehicle, we can get the degree of overlap, the impact configuration. And I had the opportunity to inspect Mr. O'Keefe's vehicle. There's no damage where these marks are. So sure, it knocked the snow off, but it wasn't sufficient to cause damage to his vehicle. I said, and watch, shoulders come in, then the head contacts the ground. What you see is if you fall backwards and land on a very hard surface or hard surface, you'll get extremely high loads on the head.
Court TV crime and justice correspondent Matt Johnson joining us live from outside that courthouse. Wow, this is important stuff, Matt. This is stuff we didn't see first time around, obviously. But Judson Welcher, a witness I think jurors will remember because of all the things that he did. But ultimately, for an expert, it's about their conclusions, about their final opinions. What did Judson Welcher say about that?
You're exactly right, because, you know, this appears on the outside to be a very complicated case, but it's only one question that you have to answer if you're on that jury. Was there any contact with the victim, Officer John O'Keefe, and Karen Reed's SUV? So this witness, by far, has to be the most important for this jury up till this point. It's the crash reconstructionist, Dr. Judson Welcher, who we didn't see in trial number 1. Trial number 2, he's part of Aperture that was paid $325,000, not himself, but the company, to do this testing. They bought that SUV for $75,000. They bought the identical clothing and shoes. Yesterday, he walked the jury through his scientific method, as he puts it, and his testing of the SUV, which you just saw right there. And today, after many objections yesterday and today, he was back on the stand, and he started his day by finally explaining his opinion. Take a listen.
So there's been 2 potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
Do you have an opinion to a reasonable degree of engineering certainty whether John O'Keefe's injuries on his arm, inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022?
Yes.
So he may, in fact, have articulated what the jury missed out on last year, a theory to what may have happened to Officer John O'Keefe, which the Commonwealth really didn't explain last year. You talked about that. I was in court when Trooper Joe Paul was on the stand last year. There were jurors that were very reactive and looking at each other with a confused look. They were shrugging their shoulders. This year, very straight-panned, and they were writing notes and leaning in. But again, it's going to be a battle of the experts with this, because ARCA will be called back to the stand.
Yeah, and last year, you know, when the battle of the so-called experts took place, it was a mismatch because of who each side was calling. And this is so different than first time around. I mean, so incredibly different. And the cross-examination has to be different as well. So let's talk about that cross-examination. Where did the defense go, and what happened during, because, you know, the test of any witness is, you know, how do you survive cross? What happened here?
Especially if you're an expert, right? And an expert as important with their opinion as this. So I just want to talk about 3 main points that the defense was really trying to attack today in their cross-examination. Was the changing of the report mid-trial, however complicated or minute that may have been, by taking out a slide, and how important that may have been to the case, and veering off from Trooper Paul's original theory last year. And then also not doing the testing at 20 miles per hour or 24 miles per hour as alleged, and also not taking into account all the people coming and going from 34 Fairview in the night in question. Take a listen to this.
You didn't do a blue paint test with the vehicle going at 20 miles per hour, correct?
That is correct. I was not going to hit myself with a Lexus at 20 miles an hour. To set up the test, because generally you only get 1 or 2 shots at it, because you damage the car, you have to know everything about the parameters. And so, again, pedestrian impacts are so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit, and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't have enough information to be able to conduct that testing.
Any time between 12 and 1, did you make any assumptions whether there were cars parked out front on the roadway at 34 Fairview? Did you make any assumptions with regard to that?
At a point in time, there was a vehicle behind it.
I'm sorry?
There was a vehicle behind it.
Just one?
That is my understanding. In terms of on the street, is your question?
Exactly.
Yes.
And what Do you remember the type of vehicle?
Yes,
What kind of vehicle was it?
an F-150 pickup.
Did you have any understanding as to whether there was a Jeep vehicle on the road at that 12 to 1 time period?
I had seen testimony somewhere to that effect, but the majority of the testimony was there were no other vehicles.
Assume that there were vehicles, at least one vehicle, parked out front of 34 Fairview. Is there a likelihood that, given 24 miles per hour over 87 feet, is there a likelihood that there would be a collision given the weather conditions as you knew them to be at that time?
Well, the weather I don't think necessarily plays into whether there would be a collision or not, but we know it backed up 87 feet. So again, it goes forward like 35-ish and then back like 60-something. And so if something is within 65 feet of the rear of it, or whatever the numbers are, I would need my slides.
It was 50.
50,
Okay. Yeah, go ahead.
57. If something is within that window, then it would hit it.
And that's very important because remember, there's been testimony from this guy right there in the first trial, Brian Higgins, where his Jeep had been parked at 34 Fairview. This jury has also seen his Jeep being moved over at Canton PD, where Karen Reed's car was taken the next day. But he hasn't been called as a witness just yet. He may be called by the defense. And remember, also part of the defense case from last year, you had the snowplow driver who said that he saw a Jeep in front of 34 Fairview. So there's going to be more to that with the defense case in chief.
Unbelievable. This is complicated for the jury. It's complicated, I get it, but at least this time around for prosecutors, you have an expert, a qualified expert, does this for a living, who says, yes, it is possible. Like last time, you really didn't have that. So that's a big change. Let's talk about some things that happened, because there's important things that happen when the jury's not in the courtroom. What can you tell us about that?
So when the jury was in the courtroom today, there was an awful lot of sidebars, and some of those became quite lengthy sidebars. Obviously, we don't know what was discussed, but then the jury was let loose for the day, and outside the presence of that jury, there was some very heated arguments, and it really went to the core as to what some of those discussions at the bench were about. And it included what was in Welcher's report, some of the images that were posted in his report that appear to be taken straight from Trooper Paul's report. Why is this important? Well, some of those photos are from Trooper Paul testing the Lexus SUV last year and what he testified to. So the big question is whether or not Trooper Paul is going to be called to the stand. Take a listen to this.
Did you get the drone image from any file from the Massachusetts State Police?
Yes.
Do you recognize any aspect of those photos?
Yes.
What do you recognize in terms of the person in it?
If I have to limit it to these three, I don't know who that is.
Okay, and if you don't limit it to those three, who would you conclude it is in those photos?
It appeared to be Trooper Paul from other photos.
When you used that photo, was it because you were borrowing, relying on, or using any of Trooper Paul's reports for your conclusions or any of your decisions or analysis in this case?
I did not use his report.
Karen, does the defense want to call Trooper Paul?
I don't have any comment, thank you.
Well, we don't know from this defendant. All of the attorneys associated with the case, they're still under gag order, so they can't answer that question. But what I can tell you is I looked at the witness lists again tonight before coming on the air with you, and Trooper Paul is listed on both of them for the prosecution and also for the defense.
So you're saying there's a chance, Matt Johnson. I get it.
I'm saying there's a chance.
By the way, nice to see you not wearing the winter coat anymore in Boston. Hopefully things are getting a little more mild. We are at the end of May, so...
I'll need it tomorrow.
Oh, it doesn't end. All right, Matt Johnson, live in Dedham tonight. Thanks so much. All right, let's bring in our think tank. Joining me live in studio tonight, criminal defense attorney, former state attorney in Miami-Dade, and former assistant DA in Atlanta. He's done a lot. He's seen a lot. Daryl Cohen. Also with us, criminal defense attorney, law professor Meg Strickler. And last but certainly not least, ever, criminal defense attorney, the man behind the glasses, Josh Schiffer. All right, let me ask you something, and you know, has nothing to do with this particular group of experts. Have you ever been in a case or been part of a case where an expert's been paid $325,000 and they have not come to a conclusion that helps your case?
To be honest with you, I've never been part of a case where an expert has been paid $325,000. Period. End of discussion on that one.
So that's a lot, right?
That is a tremendous amount of money.
Well, some of it includes buying a car, though. They bought a $75,000
I heard that,
Lexus.
and they can give it back and then talk about the money.
Right.
They're going to make more money by selling it in California.
And really, doesn't that tell you exactly about the motivation of that expert coming? Could be, you know, we complain about expert costs all the time. What do you mean it's $500 or $1,000 an hour? 300 grand?
Well, they did a lot of experiments. There's a lot of detail here.
But they just started like in what,
Well,
9 months ago?
September.
So
8 months ago. I can't do math. Yes.
Let me ask the question another way. Have you ever been in a case where an expert has been paid a lot of money, whatever it is, and they have not come to the conclusion that helps your side?
Of course.
No,
You have.
Yes, of
I have
course.
not.
You
because
haven't.
Every expert I've had, I thoroughly vet that expert and make sure he or she is going to testify to the truth, but I want to know what the truth is before we allow them
in
to
a defense
testify.
case, sometimes I might hire an expert like a vehicular accident reconstruction, and sometimes they'll be the same as what the state has said. So we've gone ahead to make sure that we do an adequate investigation, and if it ends up being the same, then we're like, okay, but we're here.
But they get paid. But
They still get paid, yes.
You get paid to do the work, and then you take their report and it becomes part of your case, even if it's leading your case in another direction.
Correct.
And I've had experts come back with a conclusion different from what I would like, and you still got to work with that.
Okay.
It helps you in building your case because they're the expert.
All right, stay where you are. We've got 3 experts with us tonight, but they're not getting paid. Not $325,000. Not even, I don't know.
Hey, we get cookies.
You get cookies. Okay. When we come back, we are very close to the end of the prosecution's case. Have they proven their case? We'll talk about that, plus coming up next hour. Tonight on Vinnie Politan Investigates, as the retrial of the century continues, we take a deep dive into the experiments done by the prosecution's accident reconstructionist. Should the jury trust these experiments beyond a reasonable doubt?
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, tonight, 9/8 Central, only on Court TV.
Karen Reed is in the midst of the retrial of the century.
She is factually innocent.
She's guilty.
There's something wrong in this county.
Come at me.
The Karen Reed Murder Retrial. Live coverage weekday mornings, 8, 7 Central on Court TV.
In a healthy gut garden,
The only way he could get this kind of an injury was to fall backwards, hit the back of his head, and then the resulting, energy forces going into his brain, into his base of his skull. His injuries were very substantial, and it's more probable than not that at some point he quickly became unconscious and was unable to do functional activities.
That's Dr. Wolf, literally a brain surgeon testifying for prosecutors, one of the new witnesses in the retrial of Karen Reed. Prosecution retooled their case, like immensely, and that was one of the new witnesses we didn't see in 2024. We saw him testify recently here in this case. Incredibly credible witness. He's a brain surgeon. I mean, he took time off in between brain surgeries to come. Like he testified on Wednesday, and Thursday he was doing 4 brain surgeries. So that's one big difference for prosecutors second time around. They also called a man named Robert Gilman, a meteorologist, talking about the weather and the conditions on the ground.
The ground was frozen, the soil was frozen, and the surface of the ground was frozen. And it would have made the ground impenetrable.
And obviously, we've been talking about another new witness for prosecutors in 2025, Judson Welcher, PhD, accident reconstructionist, working for Aperture, talking about all of those conditions on how he believes it's consistent with his science, his engineering, that John O'Keefe could have been sideswiped and struck and then knocked onto the ground and then impacted the ground with his head, causing his death. So, have these new witnesses pushed prosecutors over the top? Still with me, Daryl Cohen, Meg Strickler, Josh Schiffer. What do you think, Daryl?
Well, I think the witnesses have done, especially the brain surgeon, an incredible job. The accent reconstructionist, an incredible job. Not the question of did they do it right, depends on what those 12 men and women think they've done.
Right,
That's
but
all.
last time, and I opened the show with this, like I had a juror on from last time who was left, I don't know how he died.
Precisely.
And now we've got new witnesses directly on that issue.
And that's smart of the Commonwealth to come back and realize where they've shortfalled in the first case. Let's go address that in the second. But is it still enough? And what I keep seeing is expert witnesses who are far better quality, much more relevant testimony, but it's still kind of saying, this could have happened. This is possible. It's not, this is what happened. All this expert testimony is almost like a rebuttal to the defense's theories that so far everybody's kind of, you know, made fun of, that the defense has these wild theories. It looks like the Commonwealth experts are actually rebutting those theories.
They need to do this beyond a reasonable doubt. And I don't know if that has really been...
You don't know if it's getting there?
No, I don't know if they've gotten there.
Well, but it's more than they had first time.
100%.
More than first time. And it wasn't an acquittal first time.
More than reasonable doubt. They've proved it in my view. In my view, also, you have to look at that juror, each and every one of them, their body language, their facial expressions.
Well, Matt
how are they absorbing this testimony?
Matt talked about that today, and it was much different than last year. Now, Peggy O'Keefe, John's mother, also called this time, not called first time around. That was an emotional day inside the courtroom. But there's also something else happening in trial number 2. It's not just new witnesses being called, but witnesses from the first trial who weren't called.
Proctor.
And that list is long.
But Proctor is completely missing.
Take a look at this, Josh. Take a look at this. Let's start first just with the law enforcement. Trooper Michael Proctor, Lieutenant Michael Lang, Trooper Joe Paul, the expert last time. They weren't called. How about the people in the house, Josh? Brian Albert, Nicole Albert, Brian Jr., Caitlin Albert, Julie Nagel, Brian Higgins, Matthew McCabe were in the house at the party that night. They weren't called. How about this? Folks just connected to Colin Albert, not called. Colin Albert, Julie Albert, Chris Albert, and Allison McCabe. And then there's the potpourri department here. Paul O'Keefe not called, and the Sullivan sisters not called.
So the big question is, the jury doesn't know who these people are except from what they've been told already. If they don't meet these people from the Commonwealth, is the defense going to introduce them? And if so, how should the Commonwealth prepare, and what should the defense do? My big criticism as a Commonwealth is that they haven't leaned into their unwaivable bad facts like Trooper Proctor.
Not at all.
No,
not at all. But is this addition by subtraction for the strength of the prosecution case?
I think they tried. I think they strategically decided to bring these witnesses and not bring these other witnesses. I mean, that's obvious. That's why you obviously don't see Trooper Proctor especially, and then Trooper Paul also, because he was the quote-unquote expert. We've got better experts this time.
Less is more. They're bringing less witnesses, better witnesses.
Are they doing Daryl's kiss method? Is that what is happening here, Daryl?
Finally.
No. Are they kissing it?
No. Not enough. I would have streamlined it even more, but they're doing a better job of focusing in on what the jurors will listen to and pay attention to.
It could be.
It could be, and I don't know if this is the one they want to bang on at the end, you know.
Doesn't this open up the defense to now pick and choose? They've got a ton of people on their list.
Wait a minute, Josh. Did you just tee up our next segment? Because when we come back, what does the defense need to do in their case?
Animal clinical.
Now, as I understand your testimony, Dr. Welcher, you believe that it's possible that the Lexus taillight could have caused these wounds to Mr. O'Keefe's right arm. Is that correct?
Correct.
And more specifically, it's your belief that the lacerations would have been caused by the vehicle scratching Mr. O'Keefe's arm as it drives past him. Is that correct?
I don't know, I'd characterize it that way. What happens is, you know, there's 6,000-pound vehicles coming, and he's standing on a, you know, icy, snowy roadway area, and it's going to contact him and move his whole body and induce rotation.
Right. So it's going to contact him and, under your theory, induce rotation. Isn't it true that if Mr. O'Keefe's arm were to be flexed like it was with the test subject in your blue paint test, the lacerations on Mr. O'Keefe's forearm would be oriented in a vertical direction?
Absolutely not. If you pull up my slide 117, it'll show exactly that it is like perfectly horizontal. When you're standing like this, and this is the tail light, the laceration, when it comes across here and pushes my body, it's going to make a horizontal laceration because the 6,000-pound vehicle is going to push me out of the way. As this pushes me out of the way, it's going to drag and create a horizontal laceration across my arm.
So one way you try to attack an expert is through cross-examination. The other way you attack an expert is with your own experts. And we know the defense has their own experts. They testified in the last trial, and now they're officially defense experts hired to prove their version or disprove the prosecution's version. Let's remind you of what Dr. Rentschler and Daniel Wolf, another Wolf, but this one, the ARCA guys testified to last time.
Later, could you calculate the force that would be required to strike a person on his outstretched arm hard enough to spin him around and project him a number of feet?
If you're talking about only an interaction between the arm and the back of the vehicle, no, there wouldn't be any projection. Again, if you think about this, the arm weighs about, again, with Mr. O'Keefe would be about 11 pounds. So you still have, you know, another 200 plus pounds being held down by gravity, and the force is only acting on the arm. So essentially, the arm would be accelerated, but the whole body, because the center of mass is not being struck, would not be projected.
Is the absence of the damage that you described, the absence of damage that you described between the dent and the rest of the vehicle, with the exception of the taillight, is that consistent or inconsistent with striking an arm, an outstretched arm of a human being?
Objection.
I'll allow that.
That would be inconsistent, in my opinion.
In your expert opinion, based on all your testing, is the damage to the taillight that you saw consistent with striking a human head?
No.
In your expert opinion, is the damage to the taillight consistent with striking a human arm?
No.
Thank you, that's all I have.
24 miles an hour, once you get up to that speed, you start to see fractures. You see significant ligament and tendon damage. I mean, usually about 15 miles an hour, 15 mile an hour impact is where you start to see damage to, for instance, the leg and the knee. At that speed, you're going to produce, if you impact the vehicle, you're going to produce upwards of 1,000 pounds of force on the body, depending on what part of your body impacts the vehicle. So certainly at 25 miles an hour, you start to see significant injuries occur. There's also the evidence that we saw when we did the testing. At 15 miles an hour, where we dropped the head form, so that would be akin or like a vehicle backing up at 15 miles an hour hitting the head. We had more damage to the tail light in that test than what we saw with the subject tail light cover. So if you're going 24 or 25 miles an hour, even faster, you're going to see even greater damage, greater fracturing of that rear tail light, and we just don't have that in this case. So both the physical evidence as well as looking at the biomechanical aspects of it are inconsistent with that head injury occurring due to impact with the rear of the Lexus.
Is your analysis the same then if the arm, close to an 11-pound arm, made contact with the taillight traveling at 24 miles an hour, sorry, at 15 miles an hour, would you expect even more damage to the taillight at a higher speed?
Objection.
I'll allow it. Watch the leading, though.
Sure.
Yes, you would. If it's higher than 15 miles an hour and you have an arm actually striking that tail light, you're going to get even more significant fracturing, more damage to that taillight at a higher speed than what we saw.
So was the taillight damage consistent or inconsistent with striking an arm?
It was, our findings was it's inconsistent for a number of reasons, but it's inconsistent with striking the arm, yes, sir.
Okay.
Is this enough? Does the defense need more? Do they need their own videos? Do they need to show this jury their own experiments? What do you think? Where's the bar been set at this point?
I think Karen said it on one of her interviews after one of the court days, where she said, I want to see this vehicle hit somebody at 24 miles an hour. So they have these experts. I don't know what they're going to show, but I think some sort of video recreation and some sort of ability to convey what they want to convey in English. I think you said that last week. Then they're going to be able to win this case.
They're only going to win this case if they can convince the jurors that there's not enough, but there's reasonable doubt. And a lot of jurors think reasonable doubt is any doubt at all, regardless of what the judges charge as to whether it's reasonable doubt, what is reasonable doubt. And I think the jury is going to be very, very interested. But I think when we get this complicated, the jury, the smart jurors, will cut through the stuff, cut through the bureaucracy, if you will.
The malarkey.
The malarkey.
Right.
And they'll stop the malarkey and they'll go straight to it. They'll either convict or acquit. They should convict, but who knows what they will do? You never know.
The big question really is what the defense does starting next week, because the Commonwealth has put up their case. This is either the last or about the last witness. So they have carried their burden to the degree they're going to carry it. So if you're the defense, do you believe they've carried it enough that it deserves an aggressive response? Does it deserve a moderate or more reduced response? Or do you turn around? We were joking about it earlier. Do they show up on Monday and turn around and say, hey, we're done? They've not done their job. They've not carried this beyond a reasonable doubt.
Oh, they're going to call ARCA.
Of course they're going to.
But the question is, does ARCA need to do more this time around? First time around, they really weren't. They were hired by the feds. The amount of information that they had was less than they have now. And what we just saw from the prosecution were images that the jury will remember. I'm never going to forget the Blue Man thing.
And the key point, the cross-examinations by the Commonwealth of the defense can add to their sufficiency of proof. The Commonwealth can prove their case beyond a reasonable doubt using successful cross-examination of the defense.
No, but I think, again, just like you just said, we're a visual society now with social media. So if the defense can come up with some very good graphics, I really think that's going to change the storyline here.
And how important is it that we did not see an experiment done at the actual speed? Again, the blue arm, that's done at 2 miles per hour.
Because there is no speed.
We can't establish exactly what the speed was.
Yes, we can. We think it's a 25. They did science.
Going around 20 miles an hour, 20, 24
But
miles
that's
an hour.
what I'm saying. A video, some CGI is going to be able to show this. And that's what's going to be very effective.
I think ultimately they're going to like or dislike Karen Read, and I think they'll dislike her. And if they dislike her enough, they'll convict her. If they don't dislike her enough, they'll say she's dislikable. But we don't see enough evidence.
So where on the spectrum of importance does this battle lie? It's going to be ARCA versus Judson Welch.
Because the Commonwealth put too much weight on their experts. I feel like that's been the majority of what I saw in this trial was these experts. I feel like that's what I feel like is what I've seen and took in more than the mom, Peggy O'Keefe, and such like that. So I think the defense is going to come back and make it a battle of the experts. And what wins a case is who was more credible on what they convey as their expert opinion.
I'm going to push back on that and say, though, remember, if both of them push against each other and it's just a mess, that tends for the defense. Well, if you can't arrive on clarity, it's a defense win.
Okay, if the experts become a push, right, like a stalemate, where does the jury go to get the answer?
Just like Josh said, defense, because that's reasonable doubt.
I don't think they have any choice if the experts are equal, because there's not that beyond and to the exclusion of every reasonable doubt. But I don't believe that they're equal. I think that both the prosecution and the defense learn to need to learn from Irving Younger, who was the master of cross-examination, saying oftentimes, no questions, Your Honor.
We could be here next Wednesday talking about the same issue, but after Arca testifies. Darrell Cohen, Meg Strickler, Josh Schiffer, thank you so much. When we come back, I will reveal something else you need to know tonight, plus coming up next hour. Tonight on Vinnie Politan Investigates, the prosecution's accident reconstruction expert conducted a series of experiments. Do they prove Karen Read was a murderer, and should the jury trust them? Tonight, we investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, coming up next, only on Court TV.
What do we really know about Diddy parties?
Get a new look at the evidence and the latest from inside the courtroom. Vinnie Politan Investigates, a Diddy special report, next Wednesday night, 9/8 Central on Court TV.
Welcome back. Time to reveal something else you need to know tonight. Let's take a look at the big board and what's happening. Oh, yes, the continuation of Diddy's sex trafficking trial. As you know, no cameras inside the courtroom. You see the courtroom sketch over here. But what we do have access to are the court transcripts of the actual testimony. Let's take a listen to the testimony of Lance Jimenez, one of the investigators, as we recreate that testimony through AI.
Now, you said that you observed the Porsche. Is that right?
Yes.
Did you form an opinion as to how the Molotov cocktail got into the interior of the car?
Yeah. At the end of my investigation, I formed the opinion that somebody had lit it and dropped it, cut the roof, and dropped it inside of the front seat.
So after making these observations as to the scene, what did you do next?
We proceeded to look for any surveillance cameras. There were cameras there. I was informed that they weren't recording. We also looked for witnesses, canvassed the area. We only had one witness that was there, but they just came after the fire had already been set. So they didn't see the actual fire occur. And then I was able to speak with the victim of the Porsche in the home.
What did your partner do?
He took photos and proceeded to collect the evidence. We did collect evidence on scene.
Investigator Jimenez, after reviewing the evidence that we've just looked at, what, if any, conclusion did you reach as to the cause and origin of this auto fire?
I made the determination that somebody had taken that bottle, put gasoline inside it, stuffed that cloth inside it, lit the cloth, cut the roof of the vehicle, dropped it down inside. I believe that the cloth had fell out, burned, smoldered, and then the liquid splashed. And the bottle never broke, obviously. And then the fire just kind of self-contained inside the vehicle, causing damage, burn damage. And the origin was there on the seat, the driver's seat, that caused the most damage where the bottle had eventually landed.
What, if anything, did you conclude about whether this was a random act?
In my opinion, it was targeted for where the car was located. This car was not easily visible from the street. The car was not, there was another car in the driveway that didn't get targeted. So I believe the Porsche was targeted closer to the home.
By the way, that car belonged to Kid Cudi, who had been dating Cassie, so you put two and two together here. Wow, powerful testimony. All right, before we go this hour, please take a look at your screens. We have a missing child who needs your help. This is Ariaha Gwendalyn Williams, just 17 years old, missing from Cleveland, Texas. Cleveland, Texas, since May 27th. If you see Ariaha, please pick up the phone, make a call, make a difference. 911, 1-800-THE-LOST, or the Montgomery County Sheriff's Department in Texas. That phone number's on your screen. Let's see if we can get Ariaha to a safe place tonight. Don't go anywhere. We have another hour of live true crime. Vinnie Politan Investigates is next. In the meantime, please don't forget to hug the kids.